What's going on, everybody? TRAE4JUSTICE back in the building, coming at you guys with some more Vallow Daybell news. I mean, where do we start? So first of all, no surprise with this, but her motion to have Judge Boreski removed from the case was denied. Can you believe it? I'm just as surprised as you all that this didn't work out, but no, this useless motion that she put out did not work, and we're gonna react to that. But also, she had a pre-trial hearing for her trial that's coming up in June with none other than Judge Boreski. So I'm going to imagine she is furious. She's probably going to go directly at this guy because the reason she doesn't like him, he doesn't fall for any of the stuff that she's pulling. Like, her brain is wired as a cult leader. So she's thinking, if I just say this in this tone and in this way, he's got to fall for it. He has to listen to it, and none of it is working. So she absolutely despises him for it. But anyway, let's go ahead and listen to how this motion was denied.
Good morning, everyone. The court calls CR 2022-00124201. This is State versus Vallow Daybell. Appearances, please.
Attorney Kay on behalf of the state, and for the record, the victim is appearing virtually.
Thank you.
Vallow Daybell for the defense. Pamela Hicks, advisory counsel.
Thank you. This got set very quickly. There was a media request that I became aware of in passing, literally on my way over here. I don't have a written request. I have not read all my email because I've been on the bench this morning. Do you want to make a record with regards to the media request from the state?
No, Your Honor.
Okay, from the defense?
No.
Okay. I don't see anyone here. I thought we would address it on the record, but I don't see anyone present from the media. Okay, I assume there's no objection if they come in. Ms. Kay?
No, Your Honor.
Ms. Daybell?
I always object to them, yes.
Oh, you object to them?
Always.
Okay. Is there anything you wanted to put on the record?
No.
All right. My thought is if they come in, we can address it. All right.
Once again, nothing based in law. I just simply object to them being here. Okay, cool.
The court's, this is the oral argument on Ms. Daybell's motion for change of judge for cause. The court's in receipt of and has reviewed motion to disqualify judge. This was filed on May 20th, and the state's response to defendant's motion to disqualify judge. Ms. Daybell, I've read your motion. In summary, the way I read it, you're asking for the court to remove Judge Boreski for cause under Rule 10.1. You cite several reasons, specifically that he's denied various motions. You mentioned facial expressions. You mentioned a belt and his not allowing you to remove it. You assert that he violated your speedy trial. There's a mention of religious persecution and an allegation of personal bias. So you're going to get, and then the state's response is that simply that the defendant does not establish judicial bias, appearance of bias, or fundamental error. Of course, under Rule 10.1, the court is evaluating whether or not Judge Boreski can be fair and impartial and whether he can conduct a fair and impartial trial in this matter.
Right.
So I'm aware of the allegations.
Really quick, it is insane how somebody can be this entitled and you literally killed your children and your ex-husband because you were just tired of them like a doll that you were tired of playing with or something. Like, really crazy that this is the route she's taking, but okay.
You'll have the opportunity to go first, then I'll allow the state and to address the court, and then you'll have the last word. Whenever you're ready, Ms. Daybell.
Oh boy.
I did file this motion in this.
I'm sorry, can you pull the microphone? I'm sorry, I can hear you.
Sorry. I did file this motion in this affidavit after several attempts to. I made an oral motion with Judge Boreski and asked him to recuse himself because of the bias and prejudice that I had seen during our last trial and throughout the whole entire time that he has been the judge over all of these cases. And he refused to do so. So I thought I needed to put it in writing and put all my points in that I felt like were causing him to be biased and prejudiced against me, and that obviously you've read it, so you've seen all the different things that I put. There was an actual comment during trial when I was cross-examining one of the witnesses where he said to me directly after an objection from this state that I was comparing myself to biblical prophets, which I absolutely was not doing. And I didn't even realize it until someone showed it to me on the FTR afterwards that he had even said that, because I was in the middle of questioning the witness. And
I can almost guarantee you that did not happen. And here's the thing, I guarantee you somebody has found that part of the trial and it's nothing like what she's describing right here. She's done that before where she just kind of says stuff and none of it is actually true. It's just like, well, she interprets it in that way, so it's just true to her. Like, it's so strange. But I guarantee you he did not say that. If anything, the evidence proved that she thinks she's some kind of divine deity and she's above everyone and everything. Like, literally the trial proved that to us. Your own brother said it. So what are we doing right now? That I don't.
So there's several times that he made comments directly to me. I tried to address this with him directly in our last hearing on May 14th, where I asked him why he had denied every single motion that I had ever filed in the last year and a half. And he said that my motions had no merit. I asked him if my prior defense team, that he denied all of their motions, that they had no merit as well. And then I asked him, my prior defense team before that, all the motions they filed were denied, and did they have no merit at all either? And I asked him again if he would recuse himself from this case so that I could get a judge that was impartial and fair and have a fair trial. That is my right, my 6th Amendment right and my 14th Amendment right to have a fair trial, an impartial trial, and not a judge who has some kind of bias against me.
Also, one more thing. He was not denying all of her motions. Literally in the last hearing, he granted some of her motions. He may have placed like small stipulations on them, but he was granting some of them. But once again, Lori is just locked on to a point, and it's just no matter what, no matter what, this is what it is.
All right, anything else? Thank you.
Judge, just the prior
No
defense
response.
motions almost all exclusively dealt with motions to preclude the media. Judge Boreski applied the appropriate law in finding that the media had a right to be present and tried to limit it by saying things like they couldn't focus on the defendant's papers or things like that to mitigate any of the concerns by the defendant. All of the defendant's motions that she has filed have been without legal basis. They've been appropriately ruled on, and the state's motions that the state has won have been ruled on based upon, again, legal basis. So the fact, as the court is well aware, that the defendant has had all of the motions ruled against has no basis for bias if they're all been ruled on based upon the rules of law and the rules of evidence. So we see nothing that the defendant has provided here that would rise to a level to preclude or recuse Judge Boreski from this case.
Thank you. Ms. Daybell, you can have the last word.
Yes, also, along those lines, Your Honor, that's one thing that I asked Judge Boreski, is that he has denied all these motions with no finding of fact and no conclusion of law. I said, what is the finding of fact and conclusion of law? These are just denied, 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 denied. He's also denied several attempts for me to try to ask the state for discovery that he's just denied outright. And then as I keep filing more and more, as I find out what we don't have and I ask for it, I'm continually, even to last week, getting brand new discovery with brand new Bates numbers, stuff that they realized they never even had before that hadn't been turned over. And I've been asking Judge Boreski for these items for a year and a half. And I'm getting them 1 week before trial. We start picking our jury today. We're supposed to be doing our strikes today.
Is she aware that they have access to the same information? Like, the judge knows what she has access to. So she was given certain stuff beforehand, or like given documents. She can't just come here and now say, yeah, they never gave them to me, so this is unfair. The judge is in the loop on this and knows when and like what dates you receive things. So I have no idea why she's pretending like the judges don't know, and she can just apply some cult charm to them and they'll just go, wow, I can't believe this is going on. You guys aren't giving her information. Like, better watch out. Lori might put a high life insurance policy on you, and you know what that means.
And along those lines, I had this motion about the RAC belt that I had asked him about since we went through this whole trial, and there was times when the belt didn't fit around me, so it fell out of my clothing. We had to stop trial and I had to go fix it. And that is what MCSO recommended, that if that was too burdensome, that they would put an armed guard in the back. And because of the media that Judge Boreski has let into every single one of the hearings and the trial, that they already have an armed guard back there. So it wasn't going to cost the state any more money. It wasn't going to cost anything if he just had them remove the belt and went over the security that the MCSO actually recommended.
These are more of just, I wasn't comfortable with this, so you should really get Judge Boreski out of here because I wasn't comfortable with the belt. You're in prison for life, Lori. It's not supposed to be a comfortable situation. You are like, you're a prisoner. So yeah, the belt is going to be a little weird. Just to be as safe as possible, yeah, they're going to chain you to the table or the floor or whatever. So I don't know what she's really getting at right now.
Every single thing that I asked for has been denied. I feel like he does have a personal bias against me, and all I'm asking for...
That's a very important part. I feel like, I hope the judge noticed that, you know, put a pin in that. You just said the right part. I feel like you have a personal bias against me. But is there a legal basis to any of this? Like, I don't know.
I went through a whole trial with him, even thinking he was biased against me before the trial started. I filed for a new motion because it came to our attention through the media. The media sent Judge Boreski a clip of one of the jurors saying that he found out about my prior convictions beforehand, before his deliberations.
What?
And this is the same exact juror who was brought in twice during trial by Judge Boreski, where he had to admonish him for, one, being on his phone, and two, talking to one of the other jurors about the case. And now he's saying, well, he went on another media thing and said that he took it back. He took back what he said, so I'm not going to give you a new trial, and nothing was done about it. He refused to call them in and have a hearing and put him on the stand under oath and ask him if he found out this information prior to deliberations. It was very confusing, and everything is just outright denied. I want to go to trial. I want to have a fair trial, as fair as possible. I don't feel like I can do that with Judge Boreski, and I would like to be appointed a new judge who wouldn't know anything about the case and be fair and as impartial as possible.
You know, maybe we could check out some of the interviews from the jurors, because I know they have been doing some. I've seen some thumbnails with some of the jurors that were on the previous trial. So that's actually a good idea for maybe a later video. Let me know if you guys would like to see that.
Thank you.
Thank you. I've considered the written motion and the response, and certainly your comments today from both sides. Ms. Daybell, I find that
drum roll.
The fact that you disagree with Judge Boreski's substantive legal rulings is not a valid basis under Rule 10.1 to grant your motion and give you a new judge. The standard in 10.1 is, has he demonstrated he can't be fair and impartial? And the fact that his rulings have not gone your way is not a valid basis to suggest that he can't be fair and impartial.
Oh my goodness. Now she's going to put in a motion for you to be recused. Why did you say that? All of you are corrupt. I can't believe I didn't say that. I'm just trying to, okay, this is what Lori is thinking right now. There it is. I don't know if she really thought this was going to work. I'm so sure she did. I don't know how her legal team, because she has counsel that's sitting right there next to her, if they're not telling her this stuff, or maybe they are and she's not listening, but I have no idea why she thought this would work out.
Unless there's some other allegation of bias that's been demonstrated, I don't find on this record that it has been demonstrated. I certainly understand your frustration with the way that the rulings have come out, and it sounds like the way that they came out with prior counsel, but the things that you have cycled through at length in your motion to disqualify, I've considered all of them. You know, whether or not he should have ruled differently, for example, the example you gave with the juror, or with making findings of fact and conclusions of law in writing.
She just threw her glasses down. I don't know if you all, hold on. It's a little pixelated and it's moving a bit slow, but you can hear she put them on. She's so frustrated. She put them on, took them off, did it one more time, and this time she threw it down. Like, listen to this.
He should have ruled differently. For example, the example you gave with the juror, or with making findings of fact and conclusions of law in writing. Some of the issues you have, if you have concerns about his substantive legal rulings, you can file a motion to reconsider, or you can take them up on appeal. You can file a special action. You have a number of legal remedies at your disposal where you can make those arguments, but they're not grounds under Rule 10.1 to get a new judge. So I am going to deny your motion. Again, as for your concern about his substantive legal rulings, you can address those concerns in a different way, but it would not be under a 10.1. And on this record, I don't find that he's demonstrated that he can't be fair and that he can't be impartial. I also wanted to address the comment that he made that you illustrated. That comment alone doesn't demonstrate that he can't be fair and impartial. I'm not exactly sure of the context where he made it, but it sounds like he let you ask a question with regards to religion, and that was his decision. But again, I don't think even that demonstrates that he can't be fair or impartial in this case.
See, that's the thing too. The context of why he said that really matters. I guarantee you the way that she's saying it is not how, oh, I believe that you just think you're some kind of deity or something like, okay.
All right. So I'm denying the request to disqualify Judge Boreski under Rule 10.1. Is there anything else from the state?
No, Your Honor.
Anything else, Ms. Daybell? Nope. Thank you. We are adjourned.
What a way to end this. So as you can see, she's probably going to be really angry now because she has to go talk to Judge Boreski right after this. So let's get right into that and see how that entire interaction happened.
Observation phase, from my understanding that we did over my objection last time.
Well, we actually didn't do an aggravation phase.
Well, I
admitted-
stipulated to it.
You stipulated to it.
Correct. But in adding it to, at the end of trial, a whole guilt phase for aggravators, my understanding is that in January, the state filed their motion, the state's allegation of aggravating circumstances, right? And then my understanding is that that can be brought to the jury during guilt phase. And so, but it hasn't been dropped to them yet because it's after the indictment. So it needs to have probable cause hearing, which is the 13.5 hearing. So
Okay, this just started with Lori talking, and I'm sorry, it's in like one headphone for me. Like I mean, she's not attacking him, but she's telling him how this is going to go. Listen, you need to schedule this before anything else happens. Like, she's literally telling the judge how the process is supposed to go, and I'm pretty sure that it's not accurate. She has counsel sitting next to her. I don't know how this works really. I don't know if they're really supposed to tell her what she can and can't do, or really what their role is in this entire thing. But the fact that she has two people beside her who pretty much understand this process is kind of weird. Like, I don't know how this works, but okay.
So we need to have a probable cause hearing so that we can add that to the guilt phase, and that's something that gets taken to the jury after probable cause has been found for these aggravators that are alleged.
I think you're referring to the rules for capital cases when there's aggravators filed in death penalty cases.
Correct.
You're entitled to a probable cause hearing, depending on the aggravator. This is not a capital case.
I know it's not a capital case, and in normal capital cases, you don't have an aggravation phase either, right?
Oh man, we're playing the mix and match game. This is something that a lot of people do that represent themselves as well. They do a lot of mixing and matching with laws and like legal components that don't fit within their case. With the Daryl Brooks case, a lot of times he would mix in case law that applied to federal cases, and he would like apply it to his, which was a state case, if you know what I mean. So that's basically what she's doing, and she's angry that the judge won't just take it, but okay.
Only in a capital case.
Actually, you have a guilt phase, and then you have a mitigation aggravation phase.
Actually, you have a guilt phase, an aggravation phase, and a penalty phase.
Right.
If the aggravators aren't found as a completely separate independent hearing, then there's no penalty phase.
So with the statute for this,
I'm sorry, did you see how she looked at her from the side? They kind of had a stare down there for a moment.
Penalty phase.
Right.
If the aggravators aren't found as a completely separate independent hearing, then there's no penalty phase.
She is disgusted with the way Lori is going about this, which is understandable. Like, how insane is this? Like, the nerve that you obliterated your entire family. What are we doing here arguing about this? Like, don't let this distract you from the fact that I wish the judge, after every complaint that she has, I wish the judge would just remind her, just so you know, we're here because you literally obliterated your whole family. But so let's see how we're going to work through. Like, I wish the judge would just remind her every time. Like, do you understand you're paying for your crimes and that's why you're here right now? But she's more upset about the fact that you didn't approve some of my motions.
So with the statute for this charge only being the one statute, what are you getting out of the aggravation phase? I don't understand.
Well, first of all, the jury in the initial phase doesn't determine whether or not it's a dangerous felony, which they need to find. And then the aggravators, I think the state has a right to attempt to prove those to the jury, to offset any mitigation or to be weighed against mitigation at your sentencing.
And isn't that normally put together with the guilt phase? Like they would have that on the back page where it says the aggravators and the guilt?
No.
So are we going to have a whole nother aggravator phase in this case?
If the jury finds you guilty of the charge and the state wants to proceed with aggravators, yes.
And so we do not have to have a hearing to determine if there's probable cause for these aggravators?
No.
They're just alleged aggravators.
Correct.
And the grand jury never found probable cause for them.
Correct.
So you're saying that if the guilt phase goes through and they find you guilty, then you have an aggravator phase added to that?
That's what I said.
Okay. Hold on one second.
She literally looked at her counsel like, yeah, you guys told me a bunch of crap. Like, so I think they're kind of spoon feeding her this stuff. And maybe she just takes the info they hand her and she just completely butchers it when it comes to like how she describes it to the judge. She immediately looked at her counsel like, seriously? Is this what you guys handed me to get out of this? But let's see if her and counsel lock in here after talking for a bit.
You have the allegation of aggravating.
Okay.
It was on my desk.
Your Honor, I would just like it to be on the record clear that the Rule 13.5 that I'm talking about is about non-capital cases. I know in capital cases they call it a Cronus hearing, but this is for non-capital case?
Well, it says under 13.5A, a defendant may challenge the legal sufficiency of the state's allegations by filing a motion under Rule 16. Is that what you're talking about?
Correct.
It doesn't say you get a probable cause hearing regarding the aggravators.
Well, I'm challenging the state's allegation of aggravators by asking for a 13.5 hearing on it.
So the state's aggravators that they've alleged is that the offense involved the infliction or threatened infliction of serious physical injury. The offense involved the use, threatened use, or possession of a deadly weapon or dangerous instrument during the commission of the crime, specifically a gun. The offense involved the presence of an accomplice. The offense caused physical, emotional, or financial harm to the victim, or if the victim died as a result of the conduct of the defendant, caused emotional or financial harm to the victim's family. The next one is the defendant was previously convicted of a felony within the 10 years immediately preceding the date of the offense. This one's really not very specific. Any other factor that is relevant to the defendant's character or background. So if you were found guilty by a jury of conspiracy to commit first-degree murder, which of these aggravators do you think there's not legal sufficiency for a jury to determine? Because they seem pretty inherent in the charge itself, except for your prior convictions, which, are you saying you don't have the prior convictions within 10 years?
No, I'm not saying that. Which of them don't qualify for the jury to make that determination?
No, you're asking for me to make a determination that there's a legal sufficiency for them to go to the jury.
Correct.
So I'm asking you, if you were found guilty by a jury of the charged offense, which of those aggravators that have been alleged by the state do you think there would not be legal sufficiency for? Because as I look at those aggravators, most of them are inherent in what you're being found guilty of. Again, if the jury found you guilty. For example, the first aggravator, it involved the infliction or threatened infliction of serious physical injury. The allegation is someone shot at the victim. That's the threatened infliction of serious physical injury. So it seems like that allegation, there's sufficient evidence for a jury to decide whether that's an aggravator.
Yeah, they're all really self-explanatory. She 1000% is guilty on that. Like, the jury is going to find her guilty on that.
The next one, the offense involved the use, threatened use, or possession of a deadly weapon or dangerous instrument during the commission of a crime. Again, if you were found guilty of the charge, as the state has alleged, the jury would find that a gun was used. So that's a separate aggravator, again, that would already be determined by the evidence. The state has alleged an accomplice, your brother. If the jury were to find you guilty as charged, again, my understanding of the state's allegation is your brother attempted to shoot Mr. Boudreau. You weren't in Arizona. So if the jury found you guilty of this charge, it would mean they found you guilty as an accomplice. If someone shot at the next aggravator, I don't think it's a leap for a jury to presume there's some sort of emotional harm. So I'm struggling with what legal sufficiency you think is lacking for a jury to make those determinations. Again, only if the jury found you guilty of the charge that you're charged with.
I understand, Your Honor, but in 13.5, right, whether capital or non-capital, the state has the burden to establish probable cause, the legal sufficiency of an amended indictment. This is an amendment. This didn't go to the grand jury. Is that correct?
Right.
So now I have the right to ask for a hearing so the probable cause can be found for these aggravators ahead of time.
So you're confusing two things.
Okay?
All right. 13.5B talks about amending the charge or the indictment. Okay, your charge is conspiracy to commit first-degree murder. It's not, your charge is not being amended. The grand jury did find probable cause for that charge.
Knew this had to be the case. I was waiting for it because, like I said, I don't understand case law at all, but I know for a fact most of the time when someone is representing themselves, they're putting like two different case laws that aren't really applicable with one another, but it sounds very similar to them. So they're just thinking, oh, this is perfect, but none of it is actually something that can be used in their trial. So I figured that was the case, but okay, let's let the judge explain it.
Your charge is not being amended. The grand jury did find probable cause for that charge.
Correct.
An aggravator is not an amendment to the indictment.
It's a whole nother allegation. It's a whole separate allegation.
Difference between an aggravator and changing the charge that you're charged with. If the state were to change the charge that you're charged with, for example, if they changed it from conspiracy to commit first-degree murder to conspiracy to commit second-degree murder, there'd probably need to be a new probable cause.
Oh, I see. Okay.
Correct.
Secondly, as to the allegation that it's a dangerous offense, the grand jury did make that finding because that allegation was included in the indictment that it was a dangerous offense. So there has been probable cause as to the dangerous factor.
Okay, if that is the case, then why isn't that found in the original guilt phase as opposed to having a whole nother aggravation phase after that, as if it's a capital offense? Because there's one statute,
Well,
there's one sentence, there's no arguing the sentence, and if it's already a dangerous crime, then there's no reason to have an aggravator phase.
Did you see her legal counsel's reaction right now? I want you to see how he dropped back in his chair and he's like aggressively bouncing his leg. He's really tired of this crap. He's even getting annoyed with the way that Lori is going about doing this, but I just pay attention to his reaction in the bottom left right here.
Guilt phase as opposed to having a whole nother aggravation phase after that, as if it's a capital offense. Because there's one statute,
Well,
there's one sentence, there's no arguing the sentence, and if it's already a dangerous crime, then there's no reason to have an aggravator phase.
What do you mean there's no arguing and there's one sentence? I don't understand what you're saying.
There's one sentence for
Oh,
the charge. There's only one sentence for this charge. And if it's already classified as a dangerous charge, is what you're telling me, right? Because it's conspiracy to commit first-degree murder, that's a dangerous charge. The jury has already found that it's a dangerous charge. Then what is the aggravator phase finding? If it's already a dangerous charge and there's only one sentence.
Does the state want to respond why the state wants to proceed with aggravators?
To start with, the jury is not going to make a finding of dangerousness as part of the guilt phase per case law. That's not permitted. So the jury has to make a separate independent finding after they find the defendant guilty. The dangerous finding will include the use of a weapon and or the intentional infliction of or threatened infliction of physical injury. So at the very least, the jury has to make a finding as to dangerousness.
I agree about dangerousness. I guess the question is, why does the state want to prove up aggravators if the jury finds the defendant guilty of the charge as a dangerous offense, given the sentence?
Your Honor, in all honesty, you could ask me this, 10 years ago before Blakely was put out. As case law changes on appeals, I've had to come back before and redo a penalty phase, an aggravation phase, and re-impanel a jury. So I prefer to, since we're already going to have an aggravation phase for the dangerous allegation, to add on the other factors, and therefore I don't have to ever worry about this coming back on appeal later.
All right.
How is it not already found to be dangerous? You just said that if they find me guilty, then it will be dangerous.
I didn't say that. I said if they find you guilty, then they make a determination whether or not it's dangerous. Now, I think what I meant was when a crime involving a weapon is used, whether it's a gun, usually it's sort of a foregone conclusion that if the jury found you guilty of conspiracy to commit first-degree murder by someone shooting at another individual, that they're 99.9% likely to find that it was a dangerous offense. But it's something the jury has to do.
Right, but usually aren't aggravators for sentencing? What other purpose does it serve in this case with this charge, with one statute? You can't give me less time, you can't give me more time, you can't do anything else except for...
Oh my goodness, so she's just angry about the formalities of it. Okay, so I see that she just literally wants it to go the way that she wants it to go. But so the prosecution just explained they do this to prevent a situation where she could come back later on an appeal and get out of this. But Lori's only response is that I just don't see the point if this is already going to be deemed as a dangerous aggravator, basically, because a gun was involved. I don't... Listen, Arizona cases are so different. This like aggravation phase thing, I don't fully get it, but at the same time, they are fully explaining how it's supposed to go. But Lori's only defense against it is just, I don't see the point. So I guess pretty much the way that they've been doing it, they're supposed to throw it out now. I don't know.
I guess the prosecutor's saying she wants to cover her bases in case there's some change in the law and what a jury has to find or not find for purposes of sentencing. And they have the right to proceed with aggravators. All right, you're right in that if you're found guilty of this charge at this level, you get one sentence. But who knows what a court of appeals would do in the future if aggravators or things weren't presented. I don't know that what would be presented at a sentencing phase from your side or from the state's side, but it sounds like the prosecutor's wanting to cover her bases.
So then I'm not entitled to a hearing before trial starts to find probable cause for these aggravators that were not taken to the grand jury initially?
All right,
I'm asking.
I'm trying to explain it to you. The jury did find probable cause that this was a dangerous offense. It's included in your indictment. So they did find...
They didn't find these specific aggravators. Being a dangerous offense and these specific aggravators
Can I finish what I said,
different,
what I was saying?
right?
I didn't interrupt you. Can I finish? Okay.
The judge is, he's using his secret move once again, simply telling Lori, can I finish? Are you done? He did this in the last one. But this time, Lori may just steamroll him and keep talking because she's already angry that he wasn't recused. So let's see.
The jury did find probable cause on the dangerous allegation. All right. You're not entitled to a probable cause hearing on the other aggravators.
When is conspiracy to commit murder not a dangerous crime?
When someone says they're going to choke someone to death and they don't actually do it, it's not a dangerous crime.
There you go.
So,
No dangerous instrument or deadly weapon was used.
so because some instrument may or may not have been used in this crime, it's considered a dangerous crime?
Right.
And these
Oh my
aggravators
goodness.
that
I'm gonna go back. Just listen to this. I just want you to hear what she said. I can't believe it. Hold on.
So because some instrument may or may not have been used in this crime, it's considered a dangerous crime?
Because a weapon may or may not have been used, it's just considered a dangerous crime? Absolutely.
And these aggravators that talk about something totally different don't have to be found after that it's found a dangerous crime?
Correct.
And that is supported by case law?
Yes.
So that what? When you go to appeal, you can't say it was a non-dangerous crime?
All right. I don't know what to tell you, all right? There was a case that came out about 15 to 20 years ago now called Blakely that said a jury had to determine aggravating factors. Okay, before that, a judge determined aggravating factors at sentencing. Now a jury has to determine it. The reason it's not done in the guilt phase is we don't want the jury to confuse the issues. We want the jury to decide first whether someone's guilty or not guilty, whether the state has proved its burden beyond a reasonable doubt. We don't want them to start thinking about other things like aggravators if they have questions about whether or not the person's even guilty. It tends to confuse the jury and confuse the issues for them. So that's why we do the aggravators in a separate hearing. First, you want to make sure the state has proved its burden beyond a reasonable doubt as to your charge.
But these specific aggravators that they allege, right, the ones that you just went over, you're saying that now after you're found guilty of a dangerous crime, that they're going to go back in, and what is the purpose of that? How does it change anything after that?
I don't know how else to explain it to you. So do you have other issues that you want to bring up today?
Yes, but I would like to finish this first. So are you denying my...
She pulled the judge back onto this topic. Well, I would like to finish this, so let's go back to it.
motion to have a hearing on this?
I'm denying your motion to have a probable cause hearing as to the state's alleged aggravators.
Okay, so you're denying my motion to have a 13.5 hearing on these alleged aggravators
Correct, because
before trial starts?
you're not entitled to one.
Oh boy.
Okay.
13.5 says that you're entitled to a probable cause hearing if they amend or change the indictment.
This is not an amendment of the indictment?
It's not. There's a difference
It's an
between...
extension of the indictment. It's not in the indictment.
It's a difference, okay, between an aggravator and changing the charge that you're charged with. Changing the charge that you're charged with is an amendment to the indictment. For example, if you were just charged with conspiracy to commit
Right.
first-degree murder, all right, but the state didn't allege with the grand jury that it was a dangerous offense, you'd be entitled to a probable cause hearing as to that dangerous allegation because it's changing the charge and it's changing the sentence that you would be getting. These
But that's
aggravators...
exactly my point. After the fact, these aggravators, if they're found, what do they do to change the charge or change the sentence or change
The
anything?
judge, I'm telling you, he's going to hit her with another, can I finish? Hold on.
What do they do to change the charge
He
or
just
change the
explained.
sentence or change anything?
Probably nothing in reality. You just said it. They don't change the charge, so you're not entitled to a probable cause hearing.
Okay, then I don't want to have an
Why did they
aggravation
zoom
phase
in?
either.
Well, you can
How
not...
are you entitled to that? And I'm not entitled to a hearing on probable cause, but you're entitled to have an aggravation phase.
Well, if you don't want to attend, you don't have to attend. What else?
All right. One thing dealing with trial is that I've asked several times for headsets for my advisory council. I know that's been an issue that you said we can only have 5 headsets. Is there some way we can do that? Because it's very difficult for them to advise me on things when they kind of don't know what's going on.
If you need a break to consult with your advisory council, we can do that. I can only give so many headsets.
You said you were going to check into that. Is that something that
They
you did
said
check
they-
into and
they
there's no
can't-
more available headsets?
They can't do more than 5 on that particular system or network that they have. I need my court reporter to have one so we can do the sidebars. The state's only getting one. I get 1, so that leaves 2 for you. Whoever you want to have besides yourself, you can choose one of your advisory council or your...
But do you hear the types of things that she's saying is unfair right now? He's thoroughly explaining why a lot of these things cannot be done. But even still, Lori is just locked onto the fact that it's just not being done. So therefore, it's biased. Like, you know that this is going to be another issue, and she's gonna lump all of this into he's just denying everything when they've had this process locked in for well before her trial ever took place, and she decided to obliterate her entire family. Once again, let's not forget that that's the reason why she is locked in prison, but yet she's arguing about headphones. That is going to be yet another thing that she's going to use to say, yeah, he's just not being fair.
But you're forcing me to choose between
Oh my
the
goodness.
people that are helping me?
Sure.
Okay.
Technically, I don't know I even have to do that. You represent yourself. You're considered your own attorney. You don't even have the right...
Very true.
The right to consult. I shouldn't say that. You have the right to consult with them, but it's not a necessary thing. Because you are acting as your own attorney, you're expected to
There you
proceed
go.
as your own attorney. They don't have an affirmative duty to even give you advice under the case law for being an advisory council. The fact that they do is probably helpful to you, okay? But you chose to represent yourself. It means you are supposed to act as your own lawyer.
You appointed them and assigned them to me. I did not ask for them.
Then why are you arguing that
Okay.
they need headphones? So what? But you want them to have headphones so they can help you. So what are we doing right now?
Yeah, I did, in case you decided not to represent yourself so they could step in at trial.
Okay, well then, is an alternative that we could do sidebars at the bench so that they could be involved during
I
that
think it
time?
depends on the complexity of the question. If it's a simple jury question that, like, for example, can we have a copy of the police report? The answer to that is always no. So I think I'll have to take it on a question by question and issue by issue basis. So if it's an issue where we need everyone at the bench, yes, we can do that. But if it's a simple, quick response that we can do with the headsets, we'll do that.
Okay,
Okay.
I have one more issue.
Go ahead.
Okay. Seeing as how things went in the last trial, my question is, what does the state intend to bring in from Idaho so that I can prepare my questions without being accused by you of opening the door? How can we avoid that when almost every witness has testified in my Idaho trial? And I don't want to be responsible for doing that. So how are we going to handle that?
You do it by understanding how to be a lawyer and not asking certain questions that would open the door to them knowing about like previous charges and stuff like that. That's how you do it. How do I be a better attorney, Judge? I'm not really seeing why that's on me.
Well, I will tell the prosecutor to make sure a caution is given to each witness that no matter what the question is, that witness should not think it's a question that would require an answer about prior testimony or prior proceedings. State agrees, right?
Yes, Your Honor.
I guess they can be further advised that if they think you or the state is asking a question that calls for that sort of answer about prior testimony or a prior proceeding, that maybe we should take a break.
Okay,
All right? Anything else?
that was it.
All right, well, just as we thought, Lori was absolutely furious. She's not happy that this judge is going to stay here. Now, once again, this is the judge that will hand her sentence. And I guess she doesn't care because, like I said in another video, she has a life sentence already. So whatever they throw on top is just really extra credit at this point. This is insane that she is trying so hard to get this judge out of here when he's clearly not doing anything at all. It's just he won't do everything that I'm saying, so therefore he's biased. The part that's the funniest is how both judges have just calmly and eloquently explained why her requests don't fit within the law and how there's no legal basis for any of it. Is there anything else you need? And then she's just immediately angry. So it looks like we're probably going to get another hearing soon. I know they're doing jury selections for the upcoming trial in June, so I'm sure we're going to get some more information that's coming out. But if you enjoyed the video, please like, share, and subscribe. Hope you did something good for somebody today. Hope somebody did something good for you, and I will catch you all in the next one.